When does Posner's theory come into play? More than minor impact, diminution of value. There is not too many of saying Ehrlich case. We think it will not be efficient to grant the emotional distress damages. We are second 348, kind of reflects Posner's value. Our second 339, pushback. People should not use efficient breach theory to get away from the K. Posnerian efficient breach theory interplay of theories critique. Ignored the value of reputation. Punitive damages. Asterisk JUSTICE scalia. Textualism just the text. Illustrations Roth v. Spec. Hairdresser leaves salon and works for crosstown competitor. The sole question. What damages is plaintiff entitled to under these circumstances? The measure of damages for breach of an employment contract by an employee is the cost of obtaining other service equivalent to that promised and not performed. But in this case there's no comparative value because the salon was unable to find a new hairdresser that was as good. The best evidence in terms of market value was what the local competitor was going to pay the hairdresser, $25 more. The court uses this to assess loss value of performance in damages. Reliance damages, cost to plaintiff, not benefit to the defendant. Reliance damages equals prep performance, pre-K and post-K, plus part performance plus foregone opportunities plus collateral investments. Restitutionary Park. Reliance. What can be covered under reliance damages? 1. Preparation for performance. $ expended in preparation/planning for K performance is recoverable under the reliance interest. Expectation interest equals reliance interest plus expected gain. 2. Actual performance. Any actual performance that has already occurred can be compensated. 3. Foregone opportunities. Usually, reliance damages are limited to out-of-pocket expenses. Walser v. Toyota sales. What would it take to unwind the contract all the way back? Under this scenario, contract can stop. Preparation of performance. Foregone opportunities. Hardest to prove. Try proving. Is it foreseeable to the defendant? Reasonable certainty. Giving up an existing job and to take a distributorship. Valid foregone opportunity. That could be measured with certainty. Foresee what? Unless something that is inconsistent with industry norm. Certainty problem. How do you put a value in there? Prejudgment interest. You don't get PJI unless you are sure with high degree with specificity and certainty what the plaintiff's reliance damage was. Very rare that non-monetary damage will be granted. If at the time of the breach, the defendant does not owe, could the defendant have shown DUS. General formula 349 as an alternative to expectation damages under 347. Injured party has a right to reliance damages. Claims, defenses, lack of, prep for performance, essential reliance, foreseeability part performance, essential reliance, reasonable certainty foregone opportunity, essential reliance, causation collateral investments, incidental reliance, mitigation. Essential reliance is limited by contract price, incidental reliance not limited by contract price. The Hightower argument is that money was raised based on firm's advice. Collateral investments. Courts may not allow a party to recover for reliance costs incurred before the contract was made. See Chicago Coliseum Club v. Dempsey, but see Security Stove and Manufacturing Co. Walser v. Toyota Motor Sales. Walser and McLaughlin spend in reliance, then don't get. Toyota dealership reflects the notion that there is a choice for the judge/jury regarding type of damages, expect/reliance. For a promissory estoppel claim, serious doubt that Walser and McLaughlin could have satisfied the requirements of the letter of intent. To prove it, they obtained land and capital investment. Quantified reliance, when it's unclear or unwritten what the expectation of the contract would be, and so you cannot prove them. Look to what you were induced to rely upon. Relief may be limited to damages measured by the promisee's reliance. Restitutional damages, benefit to the defendant. Reliance damages, part performance kinda overlaps. Preparation for performance, foregone opportunities, not for restitution, but for reliance benefit to the defendant, both restitution and reliance. What to look for? Franchisee fee. Look for crappy advertising campaigns and supplier product quality problem. ODD got the benefit from the difference in price between quality stuff and crappy stuff. Labor cost argument. General formula. Computation of restitutionary damages. 370 measured by fair value of the benefit conferred. Can be measured two ways. 371. If money is awarded to protect a party's restitution interest, it may be measured by either a fair market value, the reasonable value to the other party of what he received in terms of what it would have cost him to obtain it from a person in the claimant's position. B. Unjust enrichment/wealth enhancement, the extent to which the other party's property has been increased in value. Relief may be measured as justice requires. Algern and Blair sued General Contractor by Miller Act governing the federal GVMT contract. The claim was that they are entitled to $37K that they haven't yet received. However, it will cost more than $37K if they would have completed the contract. They opt to sue by restitution. Better remedy. The measure of recovery for quantum merit, restitution, is reasonable value of perform. 347. DD tries to argue that, no, you cannot do that. There is a K. The court rejected this for two reasons. Restitution is not a claim based on contract. Court makes an argument that it is the defendant who committed total breach. We shouldn't let the defendant to hide behind the contract anymore. Maglica v. Maglica. Quantum merit allows recovery for the value of beneficial services, not the value by which someone benefits from those services. Very good example on how the wealth enhancement would work. Atix Corp v. Trans World contract term is properly ignored in this case. You just look at the benefit conferred to the defendant. 374 Restitution for party in breach 1. Breaching party may recover restitutionary damages for any benefit conferred on the other party in excess of the loss caused by his breach. Deduct actual loss to other party, even where the breach is intentional or material, with two important limitations. Limited to K-price and liquidated damages clause. A. Limited to K-price. Recovery for the breaching party is always limited to the K-price. The breaching party cannot recover more than the pro rata portion of the K-price for the work he performed. B. Liquidated damages clause. If the parties agreed that a breaching party's performance would be retained in case of breach, the breaching party is not entitled to restitution if the value of performance as liquidated damages is reasonable. This type of clause cannot be overridden. 2. Restatement view. Willfulness should not be a bar. A. Some courts say it should be a bar. 3. Right to rescind. Party in breach is entitled to restitution for any benefit that he has conferred by way of part perf. In case of breach, restitutionary recovery is limited to non-liquidated damages or unreasonable liquidated damages, in light of the anticipated or actual loss caused by the breach and difficulties of proof of loss. Lancelotti v. Thomas's agreed to sell their business to Lancelotti for $25k in the building of an addition to the property. If he didn't build the addition, he would owe them rent. He doesn't build the addition and disappears. He sues to recover the $25k minus the owed rent. Traditional CL rule was that you don't get the money back if you breach, but C 374, restitution for the breaching party is only fair value of partial performance. 360 factors affecting the adequacy of damages. 1. Difficulty of proving damages with reasonable certainty. 2. Difficulty of procuring a suitable substitute performance by means of money awarded as DMGS. 3. Likelihood that an awarded damages could not be collected. Equitable damages. Specific performance. Specific performance. Question to ask: what should unique product / unique employee? What the party expects at the beginning. O. Uniqueness, unique personality, unique audience acceptance, clearly identified individual. O. Think about how many people will have that person's expertise, skills, knowledge, etc. Which is dangerous, because the knowledge will migrate to a competitor jumping to a competitor. Direct competition between the two. How long should the injunction last? O. Option hasn't exercised. Indicates that someone isn't so unique. Maybe only first stage length. Specific performance is one type of equitable remedy. Also injunctions. You can only get equitable remedy like specific performance when other remedy is unavailable. Guideline. When SP is allowed, damage must be inadequate. 360/B. 359 Specific performance be granted. Factors. When will the SP be granted? 360 Prove whether the damages is adequate in determining whether the remedy in damages would be adequate. The following circumstances are significant. The difficulty of proving damages with reasonable certainty. B. The difficulty of procuring a suitable substitute performance by means of money awarded as damages. And C. The likelihood that an awarded damages could not be collected. Unusual 1. Leproff did not see any case that does that. 361 Specific performance be granted. Specific performance or an injunction may be granted to enforce a duty, even though there is a provision for liquidated damages for breach of that duty. Refused. 362 Specific performance not to be granted. Specific performance or an injunction will not be granted unless the terms of the contract are sufficiently certain to provide a basis for an appropriate order. 363 Specific performance may be refused when specific performance or an injunction may be refused if a substantial part of the agreed exchange for performance to be compelled is unperformed and its performance not secured to satisfaction of court. 364 Specific performance or an injunction will be refused if such relief would be unfair because the contract was induced by mistake or by unfair practices, or B. The relief would cause unreasonable hardship or loss to the party in breach or third persons, or C. The exchange is grossly inadequate or the terms of the contract are otherwise unfair. However, specific performance or an injunction will be granted in spite of a term of the agreement if denial of such relief would be unfair. B/C. It would cause unreasonable hardship or loss to the party seeking relief. 367 Special situation. Personal service. 1. A promise to render personal services will not be specifically enforced. 2. Injunction will not be issued if probable result would be to compel an undesirable continuance of personal relations or to leave the employee without other reasonable means of making a living. Reason. 1. It is not desirable to compel the continuation of a personal service relationship when disputes have arisen and loyalty and confidence are gone. And 2. Court-ordered specific performances seems to violate the constitutional prohibition on involuntary servitude. Comment. General note, case tends to fall within this too difficult to enforce category. Include contracts that 1. Turn on the satisfaction of one of the parties, 2. Require a party to make best efforts, or 3. Contain complex performance requirements. Illustration City Stores Co. v. Ammerman. Tyson's Corner lease breach dispute was an offer made to city stores by Lerner Godlewski. Yes, assurance created option contract to conditions had to happen. Tyson's had to get zoning permit and get other leases. LG gives the lease to Sears instead. City Stores seeks an immediate preliminary injunction and seeks specific performance if the lease court grants City Stores specific performance because there was no way to calculate expectation damages with any certainty. 360A. Court does not find that uncertainty of terms precludes remedy by specific performance. Specific performance will not be awarded if it would be too heavy a financial hardship, but simple economic disadvantage is insufficient. 364. Effective unfairness. Real estate uniqueness adds to the 360B argument. ABC v. Wolf. Breach of contract dispute regarding Wolf's negotiations with CBS. ABC sues for equitable relief alleging breach of contract. Good faith negotiation. Specific performance not available. B/C. It's a service contract. Issues of involuntary servitude. What about injunction? Negative injunction prohibiting him from working for another company. Contract had good faith negotiation period, exclusive/non-exclusive, and first refusal period. Wolf met with CBS during non-exclusive GFN period, signs contracts during that period. Contract had covenant not to compete. This breached his obligation to GFN. Agreed remedies. Once a non-performance of an existing contract has occurred, it is within the power of the parties to agree to compromise or settle their dispute. Absent some element of fraud, mistake, or duress, that agreement will almost surely be the final settlement of the dispute. Liquidated damages clause. Fixed or determinable sum of money has been specified in advance, has not been so warmly received by the courts. Term aimed at compensation. Enforceable clause intended to penalize unenforceable. You wouldn't get prejudgment interest. M. Liquidated damages, presumed to be valid. The burden is on the defendant to show that liquidated damage is reasonable. Cannot get both liquidated damages and expectational damages. Parties are free to include among the terms of their a liquidated damage provision for damages of their own choosing in the event of breach. 356 and U2-718, whether the liquidated damages are reasonable. Majority JDX. 1 and 2 and 3, minority JDX. 1 and 2 odd 3, Leproth thinks, if you have 1 and 2 odd 3, fine. 1. Difficulty in proving damages. At the time of making K damage is hard to compute. 2. Reasonableness of likely damages. Is the LD clause a reasonable estimate of what the potential damages are likely to be? A. Traditionally law only determined prospectively. Reasonableness assessed at K formation. Look at 1 plus 2, and if hit somewhere in between enforceable. 3. Reasonableness of agreed amount in light of actual post-breach damages. Retrospective test. A. Reasonableness assessed at breach. B. Look backwards and say, are they reasonable now? After we have seen the damages, wait until after damage is ascertained and see if reasonable. Note, the court can also look at intangible or even idiosyncratic interests, such as goodwill, brand identity. Have to show there is real intangible interest. 4th, warranties have to be specific enough. The boat is great. Too generic. Oh, but the boat is the fastest in class. That might be good. Courts will take into account of the trade usage. Warranties can be cumulative. You can assert multiple warranties. The 2-300 series. Test. When our express warranty created statement of quality. If seller makes affirmative statement about nature or quality of goods, it can become express warranty. If it is part of the basis of the bargain. Description of goods. Any description of goods can become OO if found as part of basis of bargain. Samples. If seller provides sample to be representative of future goods, can be construed to be OO. That goods will conform to sample if part of basis of bargain. Advertisements been found to create OO when they can be proven to be part of the bargain and specific enough to be considered warranties and not puffery. Show basis of bargain. UCC 22313. B. Puffing. How to distinguish puffing from express warranties? Specificity of representation. More specific the statement, more likely it is going to be OO. Degree to which seller qualifies/hedges his statements. Oh, as far as I know /my opinion, likely puffing. Oh, this car is in top quality condition. Oh, buyer's knowledge, including any expertise B may have. Oh, reasonable person would know that promise were false and not too unlikely to be construed as such. Express warranty. 2-313. Express warranties by affirmation, promise, description, sample. Express warranties by the seller are created as follows. Oh, any affirmation of fact or promise made by seller to buyer that relates to the goods and becomes part of basis of bargain creates an express warranty. That good shall conform to the affirmation or promise. Oh, any description of good that is made part of basis of bargain creates an express warranty. That good shall conform to the description. Oh, any sample or model that is made part of basis of bargain creates an express warranty. That whole of the good shall conform to the sample or model. It is not necessary to the creation of an express warranty that the seller use formal words such as warrant or guarantee, or that he have a specific intention to make a warranty. but an affirmation merely of the value of goods or a statement purporting to be merely the seller's opinion or commendation of the goods does not create a warranty comment. The principles behind this rule need not be confined to sales contracts. Note, not necessary to use words warrant or guarantee, nor specific intention to create warranty. Seller can either be merchant or non-merchant. Past deliverers may set the description of quality. Statements of the seller's opinion or commendation of goods does not create a warranty. Disclaimers of express warranties cannot contradict the warranties. However, existence of warranties may be subject to parallel evidence rule, since express warranties may be created orally, or in separate writings. 2-313, B. Reliance, how to show basis of the bargain. There is a presumption of reliance if the seller can prove that the buyer actually didn't buy in that BS. No reliance, but it is a rebuttable presumption. Question, perfectly safe for everyone to eat. Test, implied warranty, only applies to merchants in an action based on breach of warranty. It is necessary to show 1. Existence of the warranty. 2. The warranty was broken, and evidence indicating that seller exercised care in the manufacture, processing or selection of the goods is relevant to whether this warranty is in fact broken. 3. The breach was the proximate cause of the loss sustained action by buyer following an examination of the goods, which should indicated the defect complained of can be relevant as a matter bearing on whether breach itself was the cause for injury. Buyer insists on brand. If BB insists on particular brand, then not relying on SS's judgment, no warranty. But if BB says what his needs are, and SS recommends the brand IWFPP. Test, how to disclaim IWM under U2-316. 2. 1. Must mention merchantability, and 2. If in writing, must be conspicuous, stand out. Sufficient if it states, there are no warranties which extend beyond the description on the face thereof. U2-316. 3. For as is, and with all faults say I clauses disclaim all implied warranties with all faults. 1. As is clauses, or with all faults in writing, will knock out all implied warranty, including merchantability, even though doesn't use word merchantability. 2. But as is doesn't negate 2. Implied warranty can be orally disclaimed. 2-314 Implied warranty of merchantability. Seller has to be merchant. Either a dealer merchant or an expert merchant will be subject to 2-314, unless excluded or modified. UCC 2-216. A warranty that the goods shall be merchantable is implied in a contract for their sale. If seller is a merchant with respect to goods of that kind to be merchantable, goods must be at least such as o. Trade usage, pass without objection in the trade under the contract description, and o. B. In the case of fungible goods, are of average quality within the description. And o. C. Are fit for the ordinary purposes for which such goods are used, and o. D. Run within the variations permitted by the agreement, of even kind, quality, and quantity within each unit, and among all units involved, and o. E. Are adequately contained, packaged, and labeled as the agreement may require, and o. F. Conform to the promise or affirmations of fact made on the container or label, if any, unless excluded or modified. UCC 2-216. Other implied warranties may arise from course of dealing of usage of trade comment. A person making an isolated sale of goods is not a merchant within the meaning of this, and thus no warranty of merchantability would apply. Sales of second-hand goods involves only such obligations as is appropriate to such goods, for that is their contract description. If second-hand goods are guaranteed to be in a certain condition, though, that changes things. 2-315 Implied warranty of fitness for particular purpose. Seller does not have to be a merchant when seller has reason to know any particular purpose for which goods are required. That buyer is relying on seller's skill or judgment to select or furnish suitable goods. 1. Where seller at time of contracting has reason to know any particular purpose for which goods are required, and 2. That buyer is relying on seller's skill or judgment to select or furnish suitable goods. There is unless excluded or modified under the next section. UCC 2-316. An implied warranty that good shall be fit for such purpose comment. O. Buyer's reliance on seller is a requirement here. A particular purpose is one peculiar to the nature of the buyer's interest in buying the goods, whereas an ordinary use is one customarily made of the goods in question, and goes instead to the implied warranty of merchantability. Most courts hold that buyer's particular purpose must be one other than the ordinary use of the goods. However, if the buyer is demanding a more intense/advanced use of additional comments, O has to have some sort of communication. O does not apply when buyer is furnishing his own technical specifications. Comparison 2-314 and 2-315 Reliance is required in 2-315. Product does not have to be defective in 2-315. Baylena Marine Corp v. Crow, not a contemporary case. They didn't get the benefit the doubt from the buyer. Broach no express warranty. Other statements could have become trade usage. What is the reasonable ground to get off the fishing ground? Look at trade usage. Boat didn't go as fast as man wanted for deep sea fishing. Issue is whether there was sufficient evidence to support that manufacturer of sport fishing boat breached express warranty and implied warranties of merchantability and fitness for purpose. A statement purported to be merely the seller's opinion or commendation of the goods does not create a warranty. So statement about performance for offshore fishing was not express warranty, needs to prove that seller made an express warranty. Reliance is presumed, but existence of warranty is not presumed. However, for implied warranty, every sale by a merchant contains an implied warranty of merchantability, unless seller successfully disclaims it for merchantability claim. Need to establish merchantability in the trade for fitness for particular purpose claim. Seller must have reason to know of the particular purpose, and that the buyer is relying upon the seller's skill and judgment in selecting the goods. 2-316 sets forth a series of possibilities for disclaiming warranties. Words will be construed to be consistent with each other. Whenever possible to exclude/modify implied warranty of merchantability, the disclaimer must mention merchantability and the writing must be conspicuous. Knockout rule removes disclaimer if there is a clearly integrated express warranty for implied warranty of merchantability. Disclaimer can be written or oral, but must use the word merchantability to be effective for implied warranty of fitness for particular purpose. Disclaimer must be in writing and conspicuous, but does not need to specifically mention fitness. The catch-all is, if you use the words as is/all faults in written disclaimer, conspicuousness, like unconscionability, is a legal question, not a factual one. Keep in mind the possible application of parallel evidence rule for express warranties. If there is a direct conflict, the disclaimer will be knocked out in favor of express warranty. Limitation of remedies is different than limitation of warranties. 2-317 is another interpretive/instructive provision. Whenever possible, warranties are interpreted as being harmonious and cumulative, but if there's a conflict, use hierarchy. Hierarchy of warranties. Implied warranty of fitness for particular purpose. Express warranties. Other implied warranties. Implied warranties can be inferred/created by course of performance and course of dealing. Defenses to actions for breach of warranty. 1. Warranty disclaimers cannot disclaim express warranties. UCC 2-316. 1. If disclaimer cannot be construed as consistent with a new, then it is knocked out. Look at parallel evidence rule. Disclaimers don't have to be conspicuous, so can limit express warranties. If who exists, leproff, it's very hard to challenge it. Note 2. Disclaimers of implied warranties. UCC 2-316. Warranty of merchantability. 2-316. Disclaimers can be made orally or in writing. Term merchantability must be included, must be conspicuous. 1. 201b. Conspicuous, presented that a reasonable person could have noticed it. Not a jury question. Text in bold print, different color, etc. Something will make it stand out. I may be disclaimed, but must say I'm disclaiming warranty of merchantability orally or in writing. Fitness for particular purpose. 2-316. Saying there are no warranties enough to disclaim FPP must be in writing, and conspicuous does not need the word fitness, cannot be oral. Do not need to specify FPP in writing. Can say I disclaim all warranties. Illustrations. Pro 6-1. Meaning of water resistant in the advertisement so generic shouldn't be an express warranty. V. Buyer's remedies under UCC. The more likely the defect is evident, the more likely the award will. M. Buyer may cancel K and recover any portion of the price she paid, and buyer may recover 1. Covered damages, 2-712, or market damages, 2-713, plus 2. Incidental and consequential damages, 2-715. Or, note, cancellation equals rescission o cancellation declaration of total breach under the common law o rescission termination of the K for some other reason, such and seeks to return the parties to status quo ante. General situation buyer's remedies in general cancellation is available UCC 2-711. 1. If the seller fails to deliver the goods, or repudiates the K, or if the buyer rightfully rejects or revokes acceptance of the goods, because they fail to conform the K. Cancellation equals rescission / buyer cancels the K, may recover so much of the price as has been paid, plus damages, measured under either the section on cover UCC 2-712, or market damages UCC 2-713, both of which are discussed below. Buyer accepts and retains goods notwithstanding a non-conformity in the seller's tender. Remedy under UCC 2-714. Buyer who does not receive the goods, and does not elect to cancel the K. Specific performance. UCC 2-716. Concise summary. Buyer's main options. 1. He can cancel the K. 2-711. 1. 2. Whether or not the buyer has cancelled, he can cover. 3. If the buyer has not covered, he may recover damages for non-delivery. Difference between the market price at the time the buyer learned of the breach and the K price, plus incidental and consequential damages. 2-713. A. Consequential damages will include only losses resulting from general or particular requirements and needs, of which the seller at the time of contracting had reason to know. 2-715. 2. 4. Buyer may get specific performance if the goods are unique or another proper circumstance. 2-716. Sans accepting the goods. 2-601. Reject the goods, sending them back or holding them for the seller to pick up. Rejection amounts to cancelling the K. 2-712. If he rejects, he can cover by procuring substitute goods and can then recover damages represented by the diff between cost of cover and the K price. 2-713. He can recover damages equal to the difference between K price and the MKT price at the time of breach. 2-713. He can also recover incidental and consequential damages if he has taken reasonable steps to mitigate his damages, and if the consequential damages were from needs of which the seller had reason to know at the time of contracting. Acceptance, rejection, and revocation of acceptance. UCC 2-601 Perfect Tender Rule does not apply to a shipment K where the seller fails to give notice or make a proper K under UCC 2-504. Buyer may reject only if material delay or loss ensues. Buyer may reject the goods if they fail in any respect to conform to the K == substantial performance rule. Common law. UCC 2-612 Perfect Tender Rule does not apply to installment Ks. If the K requires or allows for delivery of the goods in multiple installments, the buyer may reject an installment only if the non-conformity substantially impairs the value of the goods and it cannot be cured. Further, a buyer may cancel the whole installment K only when the non-conformity as to the installment substantially impairs the value of the whole K. UCC 2-508. Even if the buyer rightfully rejects goods, the buyer is not entitled to cancel the K if the seller cures any non-conformity. Allows for cure if the seller still has time to perform under the K or the seller had reasonable grounds to believe that the non-conforming tender would be accepted. UCC 1-304. Duty of good faith. Principles of interpretation may limit the ability to reject goods for truly minor or trivial defects. Limitation of PTR 2-601 does not apply to installment Ks, where instead 2-612 lets the buyer reject only if the non-conformity substantially impairs the value of that installment. 2-508. 1. The seller gets reasonable time to cure, even if cure would occur after the contracted for time for delivery. 1-304. A buyer who seizes on a trivial defect to reject a shipment when he's really motivated by some other factor might be found to have breached his general obligation to behave in good faith. If the court thinks that the buyer is chiseling, the court may interpret the procedural requirements for rejection extra strictly. UCC 2-711. 1. Right to cancel. The right to cancel often turns on whether the buyer has rightfully and effectively rejected the goods or rightfully revoked acceptance. Whether rejection is rightful or wrongful. Presence of grounds for rejection. Determination of the buyer's right to reject begins with the perfect tender rule. When buyer has proper grounds, question remains whether the buyer takes the proper steps to make an effective rejection. 2-602. 1. Simply provides that the rejection must be made within a reasonable time and that notice must be given to the seller. 1-205. Reasonableness turns on the relevant nature, purpose, and circumstances of the action. For instance, reasonable time to inspect and reject oranges is likely to be much shorter than the reasonable time to inspect a complicated piece of machinery. Buyer accepted the goods. Buyer's right to reject terminates if the buyer has accepted the goods. UCC 2-607. 2. Buyer who has accepted the goods is liable for the K price. UCC 2-607. 1. However, the buyer does not lose the right to recover damages for breach, even if the goods have been accepted. UCC 2-607. 2. Acceptance of the goods can occur in 3 ways under UCC. Occurs when the buyer, after a reasonable opportunity to inspect, 2-513, signifies to the seller that the goods are conforming, or that she will take them despite any non-conformity. 2-606. 1. Mere possession or use of the goods by the buyer == acceptance. Buyer is entitled to a reasonable opportunity to inspect the goods. Fails to make an effective rejection. 2-602. After having had a reasonable opportunity to inspect. 2-606. 1. B. If the buyer simply holds the goods and takes no other definition steps, the buyer will be deemed to have accepted the goods after the passage of a reasonable time. OBB accepts goods if she does not any inconsistent with the seller's ownership. 2-606. 1. C. Altering or modifying the goods would be an example of an act inconsistent with the seller's ownership. Revoke acceptance of goods. 2-608. Even after acceptance of the goods, the buyer could still cancel the K if the buyer is entitled to revoke acceptance. 2-608. Requirements for revocation of acceptance are more stringent than for rejection. Non-conformity must be substantial and there must not be any change in the condition of the goods, unless caused by their own defects. Revoking acceptance. 2-608. The buyer may revoke a prior acceptance of non-conforming goods, where the defect has substantially impaired their value, if OC knew of the non-conformity at the time of acceptance, but accepted based on the reasonable assumption that the defects would be cured in a reasonable time. And they have not been, or she did not know of the non-conformity at the time of acceptance, and the acceptance was induced by the seller's assurances that the goods conformed, or she did not know of the non-conformity at the time of acceptance, because the defect was difficult to discover by then. Note, in order for the revocation of acceptance to be effective, the buyer must notify the seller of the revocation within a reasonable time after buyer discovered, or should have discovered the breach. 2-608. 2. Note, a revocation of acceptance, where successful, puts the buyer in the same position as if she had properly rejected the goods initially. 2-608. 3. Damages, specific performance and other remedies. AVAC acceptation goods have been accepted. The buyer's damages are measured under UCC 22714. The buyer may recover those damages that result in the ordinary course of events from the seller's breach. 2-714. 1. If the damages flow from a breach of warranty. 2-714. 2. General rule. Differ the time and place of acceptance between the value of the goods accepted and the value they would have had if they had been as warranted, unless special circumstances show proximate damages of a different amount. 2-715. Buyer is entitled to recover incidental and consequential damages, sans acceptation, non-delivery, repudiation, rightful rejection, or rightful revocation of acceptance. Buyer may recover damages under either 1. Market value measure, 2-713, or 2. The cover section, 2-712. Preferred, more precisely compensates the buyer for the loss resulting from the breach. Can also recover incidental and consequential damages under 2-715. Specific performance UCC 2-716 unique, or in other proper circumstances. Whilst the code liberalizes the use of specific performance to some degree, the section continues in general prior policy as to specific performance and injunction against breach. Comment 1. Other buyer's remedies 2-717. Right to set off damages against the amount of the purchase price still due the seller. 2-711. 3. Security interest in goods in the possession of the buyer for any payments made on the purchase price plus expenses. 2-718. 2. Right of restitution, when buyer is in breach for any payments made to the seller, less the seller's damages. 2-718. 1. Right to recover liquidated damages, if the K provides for a valid liquidated damages clause. 2-716. 3. Right to the repl of in goods in certain circumstances.